Poison and bow, legs built on broken backs and tears. Shadow puppet masters feeding our fears. Burning corporate fiction to the cloud. Shatter the chains that got us bound. Scream at the top of your voice so true. Tear down the walls and break right through. Oligarchs with their greedy hands tight. Central banks stealing our night's light. New alarm creeping in disguise. We see through the facade and all their lies. Burn the corporate fiction to the ground. Shatter the chains that got us bound. Straight at the top of your voice so true. Tear down the walls and break right through. Oligarchs with their greedy hands tight. Central banks stealing our night's light. New world order creeping in disguise. We see through the facade and all their lies. Burn the corporate fiction to the ground. Shatter the chains that got us bound. Scream at the top of your voice so true. Tear down the walls and break right through. Rise up, soldiers of a broken world. With tattered banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes. Rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet. Oligarchs with their greedy hands tight. Central banks stealing our night's light. New world order creeping in disguise. We see through the facade and all their lies. Burn all their lies. Break right through. Break right through. Rise up, soldiers of a broken world. With tattered banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes. Rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet.
Good morning, ladies and gentlemen, or afternoon, evening, night, depending on wherever on this tax plantation you happen to be tuning in from. How was that for a little bit of morning badassery? I guess that's something I just learned. You actually lost the topic. Gotcha. But anyway, AI, dude, kind of pretty interesting that it's able to make something that sweet just off of a prompt, Spring up a little bit of something about some corporate oligarchs and pirate bankers and commie New World Order, and bam, right? Oh, of course, burn the corporate fiction. So that's officially the song, Burn the Corporate Fiction. How about that? All right. Well, this morning, we're actually not even going to really get into news. I mean, there's a couple cool things, like one, the CDC and the NIH and all the various communist health administrative agencies have been told to shut the hell up. Meanwhile, England, I guess, is being quarantined, or the entirety of the UK. But we'll get into that possibly next morning show. This morning, I've been getting a lot of questions from you guys regarding the claim of the estate, right, and the process, and how it's done, where it's done, and stuff. So we're going to get into a little. Well, we're going to get into the basis of all that, so everybody really understands how how it's done and why it's done this specific way, right? And so we're going to get into the probate and probate code this morning is primarily what I want to talk about. But before I do that, let me say hi to everybody that's popped in here so far. We've got Beyond Elemental. Good to see you. Dylan. Buenos dias. Pushing Buttons. 62. Good to see you. One more quarter. Dylan says awesome. It's pretty cool. The song was pretty cool. It is pretty cool. Dead and Drumming. Good day, man. Jerry, son of Mick. Good to see you. Adorable. Nice. Can't fix. No, you can't fix stupid. That's a good screen name, right? That would actually be a good title for a show. And Tammy Zimmerman tuning in on the Rumble side. Good to see you. Let's see. And we've got, yes, Anti-Whiteism ends with you. Hopefully. And Kundalini King. All right. So this morning, basically what I want to start with is, one, I did set up the membership on the YouTube side. So if you're on Rumble, I'm not really sure how that's going to work out. I might have to do like the Spaces thing, or if you come over to YouTube, but I've got the basic thing set up. So this is, if you guys are interested, of course, this is where we're going to make sure that everybody who's involved is actually serious, has a little bit of skin in the game. It's nothing more than you would spend at a gas station, but I'm going to actually show you how to draft all of these actions at common law. You'll have access to my templates, to all of my common law books, and of course, my personal counsel and any of your issues you may come across. And we'll actually go through and do entire classes on drafting actions at law. Well, first, we're going to start with the reclamation of the estate. So this morning's show, and of course, even if you're not a member, I'm still doing, it's a law show. You know what I mean? This is primarily what I do is teach how the law works and how to undo the fuckery that they have done. But I will tell you, and that's the point of this morning's show, is Western Anglo common law is entirely founded upon a spiritual understanding. It's biblical, essentially. And if you do not approach common law or the understanding of law in general, because it's not just Western Anglo law, actually it goes back even ancient. There are ancient Roman maxims that say only God makes the heir, and so you have to understand that it's spiritual in this aspect of what would make you equal to every other man under a supreme law, right? Which would be natural law, the law of nature, and nature's God, right? So how could you claim to be independent of the institutions of your fellow men absent consent if there wasn't a higher lawful authority that's endowed you with rights that no other man, and of course, or woman, I mean, when I say man, I mean mankind, could ever take away or transgress or trespass upon, right? So, I mean, just the very wording of the Declaration of Independence, the various organic acts of the territories, just the structure of law, the Magna Carta, it all revolves around that understanding. And primarily that understanding as to law regards property, okay? It's the protection of property, the use of property. All crime is a form of theft. If somebody kills somebody, you stole their life. If you assault somebody, you stole their bodily autonomy. If you take their property, you just stole from them. So it's all, and because of that, and understanding that, you can see that law entirely deals with property. Okay. And this goes all the way back to the concept of the first estate granted to man. Okay. Which would be Adam and Eve, essentially. And thus comes the line of descendants and inheritance. And so we can go, I'm going to start with sharing the window this morning, and we're not going to spend too much time on like the history of estates and stuff like that, because we beat that to death pretty much every single time. But so if we go to the organic acts of the territories, which would be right here, the very first thing they're dealing with is be it ordained by the United States and Congress assembled. And government is essentially a priest. It's a priesthood. That's what government is. And the older presidents and jurists knew this, like back in the day before they hid that knowledge from everybody because they want to, promote communism. See, in order for communism to prosper, why the hell is my camera? Can you guys see me? No, stop cam, start cam. That's weird. Did my camera go out? Can you guys see me? Here, let me try. That's totally weird. That's odd. Can you guys see me? Okay, you guys can see me. I can't see me on my own screen, so I digress. I apologize for that little. Apparently, my computer's already freaking out, so they don't want me to teach you guys this stuff. So, but anyways, once we get to the organic acts of the territories, it begins right with estates and inheritance, that the estates of both resident and non-resident proprietors in the said territory dying intestate, which means without a will, shall descend to and be distributed among their children and the descendants of a deceased child in equal parts, right? The descendants of blah, 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 blah. So it's inheritance, immediately what it starts dealing with. We pop over to the Magna Carta, which, where the hell did I put the Magna Carta? I got a lot of tabs open this morning. You guys got a lot of stuff to go through. Okay. So immediately, right in the beginning of the Magna Carta, the entire thing, look right here, heirs may be given in marriage. But if the heir of such person is under age in a ward, when he comes of age, he shall have his. So the very foundation of written common law is dealing with primarily inheritance and wills. And so that's really in the way that this is all spiritual, is because property is the ultimate realization of your will. You will something to become yours, and it becomes yours to serve your will, right? That's what you have property for, to serve your will. So when you do not have absolute title to your property or claim to your property, that means you do not have free will anymore. Somebody else tells you how to use the property, fines you and fees you for the use of the property, et cetera, et cetera. And so the common law understanding is that we're all equal under God, that all men are created equal and endowed with unalienable rights, right? So the reason I bring this up, the spiritual aspect for one, and secondly, is because you have to understand that you have an estate. Whether you realize it or not, you have an estate, and you're supposed to have a house, okay? And a seal, more importantly, which is one thing I didn't pull up. I'll have to pull it up when we go over it, would be the Bouvier's definition of a seal, because the seal, a foreign seal, is its own proof, its own consideration. So we're going to use that when you claim your estate. You have to seal all your documents. One of the very first things you do is you do a declaration, establishment, and publication of your house and your house seal, so that all your documents are sealed. Because I'll show you in just a moment, right here. No, not here. Sorry. Okay, right. No, where the hell did I put that? There it is. Okay, so like this is the original Illinois state constitution, and I want to show you something. It says in section 6 of the schedule, so this is the very first constitution, and they're setting it out how the government's going to basically unfold according to this constitution. And it says that the governor of this state shall make use of his private seal until a state seal shall be provided. What does that tell you? That tells you that whoever was eligible to be governor had a house and a seal. So it was already assumed that the person that would be elected governor would have a private seal, because you are supposed to have a house and a seal. You're not seeing the Illinois Constitution or seal? That's weird. Okay. See, it's bugging out on me because of shit. I guarantee you it's because of the topic. I don't know. But hold on. All right, let me stop sharing. Let's redo this. Thank you for letting me know. All right. Now it shall work. Okay. The governor of this state shall make use of his private seal until a state seal shall be provided. Okay. So it's already assumed that the governor has a private seal, that whoever was eligible to be governor would have, it has a house and a seal. Everybody has a house. The house is essentially your family, your clan. It's the very first political subdivision of a state would be the house, right? And even to this day, the wealthy oligarchs, like say the Rothschilds, they still stand behind the political protection of their house and their seal. That's why it's called the House of Rothschild, okay? House of Rockefeller. All these people, they operate under common law because they're above this Article 1, Section 8 commercial security scheme that they've created by mortgaging your estates, which is, we're going to get into some of that this morning too. But back to the divine thing, if you do not understand, so I got this surprisingly enough from the FTC, the Federal Trade Commission. I'm totally shocked it was on here, but it's a constitutional class. Okay, so it's basically talking about, it says, we honor our founding fathers of this republic for the same reason God raised up these patriotic partners to perform their mission and called them, right? So the first presidency acknowledged that wisdom when they gave us a guideline a few years ago for supporting political candidates. I'm very surprised that they had this on the FTC, but there was a couple interesting quotes where, let me see, there's one that says, where was it? You have had the use of the endowment house for a number of years and nothing's been done for us. No, that's not it. There was there's one thing where he says, where the guy's talking about how basically the presidency is a priesthood. I really should have had it. And so President John Taylor said this, right? He said, as we have progressed, the mist has been removed. And in relation to these matters, the elders of Israel begin to understand that they have something to do with the world politically as well as religiously, and that it is as much their duty to study correct political principles as well as religious, right? He says that there was a time when the American people, this was Norman Vincent Peale, there was a time when the American people roared like lions for liberty. Now they bleat like sheep for security. And like Benjamin Franklin said, those who sacrifice liberty for security deserve neither and will lose both. This is interesting right here. He says, it's the devil's desire that the Lord's priesthood stay asleep while the strings of tyranny gradually and quietly entangle us until, like Gulliver, we awake too late to find that we could have broken each string separately as it was put upon us. Our sleepiness permitted enough strings to bind us to make a rope that enslaved us. Yeah, and that's where we're at right now. Okay. Here it is, President Marion G. Romney. Okay, he says, we who hold the priesthood, which is what government is essentially a priesthood. Okay, because the original lawgivers were the priest class, and so were the original minters of currency. So, like back in ancient Greece and ancient Rome, these the money would have the face of the god or goddess of whose temple minted the currency. Okay, and the priest class were the ones who were the lawgivers, because it's an ancient understanding that law is only made by the creator. However you interpret or have a relationship with the creator, law is only made by the creator. Men can only regulate commerce. That's all we can do. Everything we do is called statute, code, or canon. You can never call it law. The only time it has the force and effect of actual law, which is common law based on natural law as expressed in society, the only time that you could create something that has the binding effect of law is, one, if a person agrees to be under it, or two, by contract, obviously, or two, if what you have written into statute or code actually is just a reflection of law. Okay, so like if you create a statute that says you're not going to kill people except in self-defense, right? Then that reflects natural law, and you don't have to be under contract for that to be binding against you. you'd have to be under contract for them to use the code or statute as opposed to just the law against you. But it's still, it doesn't matter if you be like, oh, a man wrote that. Well, no, it's still the law. So it doesn't matter. That's what Marbury versus Madison means. Any law repugnant to the Constitution is null and void, because men do not make laws, period. So we see this. He says, we who hold the priesthood, we who hold the priesthood must beware concerning ourselves that we do not fall into the traps he lays to rob us of our freedom. We must be careful that we are not led to accept or support any organization, cause, or measure which in its remotest effect would jeopardize free agency, whether it be in, and there's that free will, whether it be in politics, government, religion, employment, education, or any other field. And that was President Marion. And it's interesting, he acknowledges that we who hold the priesthood, because those in government, that's essentially what it is. It's a form of priesthood, without question. Government is a religion unto itself, I guess you could say. And that's why originally our government here in the United States and over in England was originally it's Christian. So it's not that the government just applies the Christian laws to society, essentially. And I'll prove it again too. And I'm not going to stay too much on it, but I do want to hammer this point home, because before you even endeavor to have to start learning how to do this stuff or reclaim your estate, you have to understand, whether you want to believe it or not, this is how law works. And they know it. They know it. Even the satanic judges, they know it, right? They hate it because they want to be God, but they know it, right? That's why they wanted to take you out of the realm of common law and place you into this contractual commercial law, where they can make up whatever arbitrary rules regarding the use of your property, including your body, so they can be God. That's ultimately what this whole story is mankind trying to usurp the lawful authority of the divine and enslave the rest of humanity and become gods on earth. That's their goal. That's what they want. So we've got James Madison said this. He said, here, I'll try to zoom in on it for you guys a little bit. Wow, that's not going to work because then I won't be able to read it. So, what was it? It says James Madison is known as the father of the U.S. Constitution. He was also the fourth president of the United States. He was the primary author of the Bill of Rights and engineered the Louisiana Purchase in 1803. Madison believed Christianity to be the foundation upon which a just government must be built. Writing on June 20th, 1785, he said, right here, he says, religion is the basis and foundation of government. That's absolutely true. Any historical study of law will show you that. The only non-religious government is commercial government, is Lex Mercatoria, which began with the Hammurabi Code. And if you read the Hammurabi Code from ancient Babylon, all it is maritime law. It's talking about international and domestic trade and how it's to take place, the weights and measures, and how somebody can be, how you basically commit commercial crimes. And so and if you remember what Babylon was known for, right, it was trying to basically breach the gates of heaven. So we're still in the same situation. So this is where it gets more interesting. It says in 1788, Madison expounds further. He says, we have staked the whole future of American civilization, not upon the power of government, far from it. We have staked the future of all of our political institutions upon the capacity of mankind for self-government. Remember, because we're sovereigns without subjects, where pure government is not above us. Your rights end where another's begin. And as long as you do not transgress another person's rights, natural rights, by essentially harming their property, which includes their body, or taking their property, which includes their body, then you're not committing a crime, right? So anything else is just the violation of contract to be disputed in equity, and it's not actually the breach of a law or a crime, it's the breach of a contract. So so he says, we're stake the future of all our political institutions upon the capacity of mankind for self-government, upon the capacity of each and all of us to govern ourselves, to control ourselves, to sustain ourselves according to the 10 commandments of God. This is what common law is founded on. And this is what the United States unequivocally was founded on. And if you cannot accept that, you're not going to be able to learn the things I have to teach you. So to move forward a little bit, and I'm not trying to alienate anybody, but to understand what your house is, the house is the most perfect form of, or as close to the most perfect form of government we can have. It's the mother, father, and children. Okay. And it's all voluntary. It's voluntarianism, right? It's like you participate, make sacrifices, and abide by certain laws and rules within the family for the prosperity of the family. Okay. And it's also your very first, it's a reflection of natural law, the way that the marriage in the house operates. So we'll move forward and we'll go here to the Bill of Rights from that same Illinois Constitution, the original one. And so this is that the general, great, and essential principles of liberty and free government may be recognized and unalterably established. We declare that all men are born equally free and independent, and have certain inherent, right? And there's that word inheritance, inherit, because you inherit your freedom, your liberty, all the way back from the first man and woman and the first estate. And that's where the natural law philosophers of the Enlightenment era, like William Blackstone, for instance, or John Locke, this is who inspired the founders to create this republic the way that it was created, where everyone's equally free and sovereign. And the only person who can take away your freedom or fine or fee you, like it says in the Magna Carta, are your peers, other sovereigns. And it takes a jury of them to do so. Okay, so you have to have a quorum of, well, more than a quorum, a jury, 6 to 12, or a grand jury, if it's an infamous crime, to actually take your liberty from you. Okay, because not any one man, no judge sitting up there in a black robe can take your liberty for not having paid for permission to use your own property in the case of driving on a suspended license, which is just absolute fucking piracy. Okay, so he says that all men are born equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, and of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. That all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. Now, right here is where we get back to the spiritual aspect. This is section 3. And I'm sure the satanic politicians that exist in Congress and state and federal and the executive branches, which it's all just administrative at this point, they despise us because they want to suck the devil's. Never mind, we're on YouTube, but you get what I'm saying. Section 3, that all men have a natural and indefeasible right to worship Almighty God. It's just how they put it. See, the separation of church and state is not what people think. First of all, that was a case that came later from the Supreme Court, probably a satanic justice. And secondly, all that meant was that you're not supposed to have allegiance to any political or any particular religious institution because of the threat that the Catholic Church had presented over the liberty of, because what people don't realize about the Catholic Church, and nothing against the Catholic Church, they have, the government be like, fuck Pope Francis, he's terrible. But, and there's a lot of corruption, but like they have a lot of the secrets, I think, and they have a lot of the original teachings going back to the time of Christ and all, but I'm not going to get into that. Anyways, you're not supposed to, they're also a political institution. And that's why there's a separation of church and state, because you can't have the president, be subject to the Pope and then also act in the best interest of a free people, especially when the Pope is part of the Treaty of Verona, which got together with the monarchs and swore to take down popular government, which I also have in my PDFs. So, and it's from congressional record. It's not a conspiracy theory. It was entered into congressional record. It's, we're not going to get off into that, but I have shown it before and I can, if anybody doesn't believe me. So, anyway, so, they have the indefeasible right to worship Almighty God according to the dictates of their own conscience, that no man can of right be compelled to attend, erect, or support any place of worship or maintain any ministry against his consent, that no human authority can in any case whatever control or interfere with the rights of conscience. Like, say that you, well, right there with the Social Security, which is Title 42, Section 666, which 4 and 2 is 6 by itself, right? That says that you need to use your Social Security number to get any form of licensing and all that stuff. Well, that kind of affects the conscience of Christians who know better. And that violates right here Section 3 of Illinois' Bill of Rights. And see, these Bill of Rights aren't specific to each state. They're basically just common law. That's it. So like what you'll read in these Bill of Rights or in the organic acts of the territories and all that stuff, it's pretty much just a rewording of what's in the Magna Carta. So religion, as we were talking about, Jerry Son of Mick says it's another fake layer to keep us from our inheritance, no matter the religion. Well, that's the whole thing. But there is, regardless of how you feel about it, I'm trying to explain to you that common law actually descends from one religion, though. That's how it's my point. And that religion is Christianity primarily. So that's what I'm trying to get across. And this is where the concept of house and seal and estate and all of these things come from this. And Rome even had the same thing. So I mean, it's not really, but as long as we can get on the same common understanding that you're supposed to have a house, a seal, and that your seal. So here, while we're on the subject of seal, before I move on from there, let me go to, I got to go to Bouvier's because he has, Bouvier's Law Dictionary. Well, I'm surprised I don't have 1215.org saved. That's weird. There we go. Okay, so we go here, we go to seal, S, right? And seal. Now, this is interesting. You guys will understand how important a seal is when we read this. Damn, it took me way up, didn't it? Okay. So seal, conveyancing contracts. A seal is an impression upon wax, wafer, or some other tenacious substance capable of being impressed. Right? Lord Coke defines a seal to be wax with an impression. But see, when in our republic, it became more lax, and you could just use an embosser as a seal. It's what courts just use a stamp now. But generally, like on your birth certificate, it's an emboss. And why do you think the courts and the state and all these various institutions have seals, but you don't? Well, just like I was saying, in the Illinois Constitution, it was supposed that whoever was eligible to be governor would have a seal. Okay, so one of the very first things you have to do when we're talking about reclaiming your state is to establish and publish your house and your seal. Okay, and so you actually have to get a seal. But the beautiful thing about the seal, because they use seals, so when you start sending them documents that are sealed, they shit themselves. You know. They shit themselves because that seal is okay. Let's get to it. So what it says right here, this is the common law definition of a seal, right? So now we're going to get back to the bottom. So here you go. Merlin, look at this. Merlin defines a seal to be a plate of metal. That's a typo. A seal to be a plate of metal with a flat surface on which is engraved the arms of a prince or nation or private individual or other device, with which an impression may be made on wax or another substance on paper or parchment in order to authenticate them. So one of the first things you're going to also do is seal your birth certificate and endorse it, right? Because that represents that's the title to your estate. And once you seal it, it authenticates it immediately, which makes it the original certificate because you're claiming it and you endorse it and you're going to put that on the record. But we'll get to that when we actually go through that class. When a seal is affixed to an instrument, this is where it gets really interesting. When a seal is affixed to an instrument, it makes it a specialty. And whether the seal be affixed by a corporation or individual, the effect is the same. So we go over here and we'll go to the free dictionary. What's a specialty, right? So we'll go up here and we'll go specialty. And of course we want Bouvier's definition for it. So you go to legal dictionary, boom. Specialty, a contract under seal. A specialty is a written document that has been sealed and delivered and is given as a security, because that's another thing. Everybody knows the saying, signed, sealed, and delivered. Whatever happened to sealed? This was a common thing. They've taken the knowledge of this away from you because a seal is one of the most powerful tools at law. That's why notaries have a seal. That's why the clerk has a seal. It's why all of these people have a seal except for you, and you have no protection. The seal makes the contract a covenant. The seal gives the consideration of your house to the document. You're basically putting the honor of your house on whatever you're sealing. Okay. And yeah, there was a thing called honor, and people actually abided by it not that long ago, right? So it says a writing sealed and delivered containing some agreement. In a more confined meaning, it signifies a writing sealed and delivered which is given as a security for the payment of a debt, which is why there's a seal on your birth certificate. Your birth certificate's actually a check. It's the very first mortgage upon which all other securities are generated. It's the pledge. You're pledged. And we're going to get it. I got the probate code up. I went and found that for you guys, the Michigan one, right? So it says, although in the body of writing it is not said that the parties have set their hands and sealed, yet if the instrument be really sealed, it is a specialty. And if it be not sealed, is not a specialty, although the parties in the body of writing make mention of a seal. So it has much more force and authority. We're going to pop back to the definition of seal because this is where it gets interesting. Where an instrument concludes with the words witness are hands and seals and is signed by two persons with only one seal, the jury may infer from the face of the paper that the person who signed last adopted the seal of the first. Your birth certificate only has one seal. Court paperwork only has one seal. So you're coming under their house in a general sense, even though it's very just basic way of looking at it. It's not, they're not actually a house, but in a way they are, in the same way you're supposed to have a house, right? So you sign something and it has their seal on it, but it does not have your seal on it. You're coming under them. You see how powerful this stuff is? And no, so it depends. If he started his own house, so you've got anti-white as amends with you, he says, would each son make a new seal once he has his own house under the larger house of his father, patriarch? Well, see, not necessarily. It depends on if there's some sort of like, if the son wanted to break away from the father and that house and start as a, but generally the son becomes the heir to the house and the estate. So he would use he wouldn't even use the seal until he became the heir or took over. So say like he reaches a lawful age and he's 21, right? And the father goes, you as the father, you go, well, okay, now you're the heir and I'm handing this over to you, and you give him the seal and allow him to be the lawful head of the house, even though you're still alive. You know, that would be, you know, a way he could get it prior, but generally he would inherit your seal because the seal is the house seal. Your father will have inherited the seal from his father, and his father will have inherited the seal from his father, and so on and so forth. And that's how important bloodline, and, you know, from your name, you should know, that's how important bloodlines and heritage and inheritance are. And it goes all the way back. Why do you think the Bible has literally an entire section devoted to genealogy? Why do you think the kings and queens and the presidents and aristocrats of our society all keep track of their lineage going all the way back to Charlemagne? Because it's important. We are just chattel now. We're just ignorant. We don't know. We're not even real men and women to them. We're humans, right? We're basically just animals that are more intelligent than your average animal. We're beasts of burden to them because we don't know this stuff. And that's the whole point. Now, this is where it gets very, very, very important for you to have a seal. The public seal of a foreign state, which you will be to the United States, right? So when you seal your documents and put it on the county record, and I'm going to get to that in a second too, because somebody asked me a question about that in the comments this morning. But when you seal your documents and you submit it on the record, it proves itself because you are a foreign state. You're foreign to the United States. You're expatriating, right? What you're allowed to do from the Expatriation Act that they passed just before the 14th Amendment, where it actually differentiates between American citizen and a United States citizen or a citizen of a foreign state, right? And public acts, decrees. So anyways, the public seal of a foreign state proves itself, and public acts, decrees, and judgments exemplified under the seal are received as true and genuine. So an act is an action, right? So this is what I was asked this morning is how do you claim your estate, right? They asked, I forget what they asked, but they asked if you had to go to a clerk, and no. You go to the clerk. Well, you go to the Register of Deeds or the county recorder. It should be called county recorder, but since we've been so infected with English and Roman law for a long time now, we're not supposed to have a registry system, period. Okay. Now, Michigan started out just calling them register, but Michigan was already laying the groundwork for all the English law. We're going to get into that and the probate of everybody's wills before they even became a state. Okay. And you've heard me say that many times. I'm going to actually go through and show you the progression of the probate court this morning. And we're going to get into some of how they actually take your estate. But with that being said, the recorder of the recorder of deeds, or sometimes called register of deeds, a deed is something done. It's an action. Okay, so most people think of the term deed as in land, like a warranty deed or whatever, right? But that's not just what a deed is. A deed is evidencing ownership of a land, but a deed is also something done, right? So you go to the register of deeds or the recorder of deeds to put your claim on the record, but the way you're submitting your claim on the record is it's your will, because remember, this all goes back to will. And property is the ultimate expression and realization of your will. And so everything is your will, and they always need your consent, because that's the one law. That's like the one main law is they cannot mess with free will, period. That's just what it is. That's why they go through such great lengths to engineer consent. That's why they went through such great lengths to trick you into so many different contracts and drag you into commercial law. See, if they could have just outright overcame you with force and established a dictatorial tyranny, then they would have. But they could not, because the people are sovereign, especially in this republic, and sovereign people must abandon their sovereignty by their own act of free will. You cannot just take somebody else's will like that. So, and that's literally why they've gone through such great lengths to trick everybody through contract, or why they try to engineer your consent through television for various things that they want to do, or social media. They show you what they're going to do before they do it, but that's a whole other topic. So the public seal of a foreign state proves itself. You have to have your seal. So you go to the county recorder, you're going to establish and publish your house seal, your house and your seal, right? And then you authenticate your birth certificate, and then you do your declaration of claim, right? And all of this gets put on the record. Now, whatever goes on the public record stands as, if it's unrebutted, it stands as the highest form of evidence in law, at law. And so once you have filed all this paperwork, then you put all the proper people on notice. And this is stuff I'm going to be teaching in the membership classes. And we're going through exactly how to do it. But once it's on the record, it gets a public record number and everything. And so what the public record is, let me give you guys an example. So we're talking about real estate and personal estate. Okay. And so it's all your estate in general. So when you would used to sell land, so the land was issued by land patent. I was talking to Grok and got it to tell me all this stuff. Like, I already knew it, but it's just funny that the AI on X actually will admit this stuff, right? And the office of the president issued a land patent. Okay. And then essentially you would acknowledge the land patent on the record, and it becomes yours, right? And there's an addendum clause on it, which means to us and our heirs forever, essentially, right? In perpetuity. And so once you got the land patent, say you wanted to sell the land. Okay, if you wanted to sell the land, what you would do is called livery of season, and it's actually a ceremony in front of 4 witnesses, a quorum of witnesses. Okay, and the person would give you the money or the cattle or whatever they were trading for the land, and you would literally pick up a piece of the land, whether it be like grass or dirt or whatever, and you would hand it to them in a ceremony. There would be an exchange. You give them essentially the land in exchange for your consideration, whether it be money, actual money like gold or silver, not paper, debt notes, which is not money, or cattle or something of tangible value. Then you would put it on the record that you sold this land to him, that you're transferring the title to this person, and he would acknowledge it on the record. And once that sale and acknowledgement was put on the record, then that transfer of title is in the land record to that person with witnesses, and then it goes to him and his heirs forever until he decides to sell it. And that's how the record works. So whatever's on the record stands as a fact at law, and it allows the world to know, this is my property, right? Or this is what it is right here. So once you put it on the record, when you send it to everybody who's concerned with your estate, who has an interest in your estate, they have, you give them 30 days to rebut it, which how can they? What are they going to say? No, you're an infant and I'm administering you. No, they're not ever going to say that or do anything about it. And after 30 days, or even in the interim, if you have a traffic ticket or whatever, and you've got this on the record, but it hasn't been 30 days, you just send it. Well, you always send it to the judge. You send it to whoever, because they're all just special administrators anyway of your estate. It's not actually a court. There's not actually a crime. You're not under common law, right? It's all just the administration of your trust. You didn't use the property the way that we told you to because you're an infant and it's not your property. You're just a trustee of the estate. So now we're going to fine and fee you. We're going to transfer your homage and service over to the court, and then we're going to create a constructive trust out of a portion of your estate, which is you. And then we're going to create a new trust where you have to perform these obligations, like pay this fine or be on probation or whatever the case may be. And then we generate securities. And if everybody remembers what securities, they're evidences of debt, whether it be bonds, traffic tickets, probation fee coupons, whatever. And then they sell those to private institutional investors. That's how it works. So once you have that on it, you send it to them, they're not going to be able to disprove it either. So it doesn't even matter if it hasn't been 30 days, right? So anyways, I digress, and I just wanted to get to that seal portion. So now that we understand that all of this is spiritual, that you do have a house and an estate, and you're supposed to have a seal, right? Well, you're supposed to have a house and a seal, and you do have an estate that's evidenced by the birth certificate now that's been mortgaged. We're going to actually look in. Oh, here's another thing I actually wanted to bring up. Another beautiful thing is when you go to file this paperwork, right? It's in the Magna Carta right here. And this is from the Michigan compiled laws of 1929. All states have to honor this because they're using the Magna Carta to administer your estates. Okay. This is the first document in the Michigan compiled laws of 1929 when they blended the jurisdictions together, right? Or attempted to, because you can never really blend them. That's why they always have trouble, with making all of this uniform. They need everybody to forget common law in order to make this go off without a hitch. Well, this is the first law book called compiled laws. The rest of them are called revised statutes before this. Now it's ever since 1929, which you'll notice is right before the Depression and the bankruptcy and the converting over to slave notes. They said Michigan compiled laws, and they're using Magna Carta. This is also the first time the Magna Carta is listed as the first document, which is the origin of jurisdictional authority. That's why they have it in here. This is listed before the Declaration of Independence. Now, that's how they administer your state. But that's why I made the show Double-Edged Sword, because it can also be used against them. Now they have to honor everything that's in it because it's in their own law book. So they can't feign to not know that they're using the Magna Carta and that they have to honor what's in the Magna Carta. And the reason I bring that up is because, let's see, where was it? I think it's 36. I want to say 35, 36. Yeah, right here. Okay. Let me close this back up. Okay, so 36 says, nothing from henceforth shall be given or taken for a writ of inquisition of life or limb, but it shall be granted freely and not denied. And the better translations from the Latin say, all matters of life and limb shall be considered gratis, right? Which means that they cannot charge you, fine you, or fee you for submitting any documents that regard your life or limb, and they must accept all documents regarding your life and limb. And the reclamation of your estate, 100% is a matter of life and limb. Good morning, Alden. Good morning, Dorian. It's good to see you guys pop in. So right here, they can't charge you. Use this. Be like Article 36 of the Magna Carta says that you're not allowed. It's unlawful for you to charge me anything for a matter of life and limb, and I'm reclaiming my estate, which includes your body, your sweat equity, everything you need to live. It's the reclamation of it. Okay. So, all right. Now let's get into the probate code, shall we? A little bit, right? So when you look for the probate code of 1939, because this is after the bankruptcy and the Great Depression and everything, and now they've confiscated all the gold and they've mortgaged the estates, or they're in the process of mortgaging the estates to secure the issuance of Federal Reserve notes. Check this out. Probate courts, decedents' estates, guardians and wards, fiduciaries, estates of disappeared persons, right? From the Set the KV, because they're also using that. Testamentary trustee, because the Set the KV Act of 1666 and the earlier ones merely built upon the ability to administer wards from the Magna Carta. So they did this over a long period of time, step by step by step in England, and then grandfathered in over here. And that's what we're dealing with now. But notice it says repealed, 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 repealed. No, all they did was piecemeal it out once they already had it all in one section. And now it's almost impossible to find, except for you guys know me. Of course, I found it. And we're going to go through it. It's actually right here. Boom. And it's all there. They don't want you to read this. But if you try to look for the probate code of 1939 from Michigan, it's impossible to find unless you go to this old historical website, this website that has the historical compiled laws and revised statutes and all that of Michigan, Hathi Trust. And I actually have another secret weapon. It's actually this, but I don't even want to show it because next thing I know, the fucking website will be taken down. I'm serious. That's how it works sometimes. It might sound paranoid to you, but I'm telling you, they don't want you to know this shit. So what we're going to do is we're going to start with the origin of probate court. Now, it's amazing because nothing in the constitutions of any state or the federal constitution or the Articles of Confederation, nothing ever mention anything about probate. But probate is the ecclesiastical court created by William the Conqueror that he gave the power over life, death, and inheritance. And so this has been their secret weapon the entire time, to take the property of free people, for the priest class to take the property of free people. Okay. And they've been doing it for centuries. And in Michigan, without having a king and by making the people stupid, it was just carte blanche, smorgasbord of taking everybody's property. In Michigan, before they ever even became a fucking state, they already had this in mind. This is from 1827. Michigan didn't even ratify its constitution until 1835. And this is where they created the court of probate for the Michigan territory. So you go right here, it says here, let me hide this. So this is from 1827. Okay, guys, this is almost 100 years old. And right here, it's bam, acting an act for establishing courts of probate. Okay. And approved April, I think that says 12th. There's a big gouge in it, 1827. Right. So it gives them a whole bunch of powers, even though nothing, and this is what Thomas Jefferson meant by the judiciary, the constitutional judiciary shall work like gravity by night and by day to usurp the sovereignty of the states. He was talking about the probate that never had to be put in any of the founding documents. They just grandfathered it right in. And with the judicial branch under common law, under the Magna Carta, it was well known and accepted by everybody who participated in law, government, and, that would be most people at that time, that there was such thing as probate. And that this was, it's a necessity in a society because it allows for property to not go to waste. So if somebody dies without a will, or if somebody dies and their heir is not capable of managing the estate, it's all about the preservation and redistribution of property. So in order to make sure property doesn't go to waste, and that's the whole pretense that they use behind probate to take property from people who are misusing it. We're going to get into that. But also, if someone's not of lawful age, then the probate court would take that heir into wardship under guardianship and administer the estate until he came of age, right? So it's kind of a dual natured thing. It is necessary because if you had people who were irresponsible, they own large portions or, decent sized portions of property, they die intestate or they just disappear, but nobody can claim or resell that land or do anything with it because nobody knows what happened to the owner and there's no way to get the title. This is what probate and ecclesiastical courts were created for. But it's also the double-edged sword of being able to just take people's property under presumption, which is, so other than signing a contract to come under some sort of private law, this is the only other way you can come under private law is through presumption. We're going to get into this. So this basically says that there should be a suitable person in each county within this territory, register of wills, administrations, accounts, blah, 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 right? So we'll go down here to the powers, empowering the judge of probate to appoint guardians to minors, right? So let's see. Okay, section 2. Let's see if we can zoom in real quick under section 2 so you guys can see this. Okay, let's hide this. Okay, section 2, that it shall be within the power. So remember, before they even became a state, created a probate court. And then in this, they give the probate judges this authority, that it shall be within the power of judges for the probate of wills within their respective counties from time to time upon request made by the friends or relations of any idiot, non-compos, which means incompetent, or lunatic person, or by any other person of the county where such idiot, non-compos, or lunatic person lives or is an inhabitant, to direct any 3 discrete persons of said county. Now, it's funny because that's directly from the Magna Carta, right? It actually says 2 lawful and discrete men of that fee is what they give the guardianship over to. And if those people misuse it or cause anything to go to waste, then it's transferred to another 2 discrete and lawful men of that fee. So they're using the exact verbiage right out of the Magna Carta, okay? And so discrete persons, 3 discrete persons of the said county at his discretion to make an inquisition thereunto. And if the person said to be an idiot, lunatic, or distracted, like what the fuck is a distracted person, right? Like what is that? How do you define distracted person? Oh, I could probably look in an old dictionary, but I don't want to get off topic. Anyway, shall be adjudged by the persons appointed to make inquisition, or a majority of them to be incapable to take care of him or herself. They shall certify the same under their hands to the judge. The said judge of probate shall be empowered to assign some suitable person or persons to be guardian of such idiot, lunatic, non-compos, or distracted person, directing and empowering such guardian or guardians to take care of such person, and the estate, both real and personal, of such person, and to make a true and perfect inventory of the estate to be returned unto and filed in the probate office of the county, right? So this is directly from the Magna Carta, okay? That the judges of probate in their respective counties are also fully authorized and empowered upon the complaint of any heir, creditor, or other person having lawful right or claims in expectancy to the estate of any idiot, lunatic, non-compos, or distracted person, as well as guardian or guardians to proceed with any person or persons suspected of concealing, embezzling, blah, blah, blah. And then 10 years later, well, 9 years later, in 1836, which I didn't pull it up, but I've shown it before, Then they give the judge of probate the ability to grant license to the guardian of said idiots, lunatics, non-compost, distracted persons, whatever, to sell their property for their benefit, quote unquote, by the way, right? So that right here, you just have the ability of wealthy people to take all the less wealthy people's shit under presumption, right? Let's move on. This is Michigan's wretched for this shit that I'm going to show you guys today. So this is what it advanced to. So this is from 1939, right? So the judge of probate in each county in all proper cases appoint guardians of inhabitants or residents of this county, and also to such as reside without the state and have any estate within the county as follows, right? So right here it says, of any person who, of the person of all such minors who are inhabitants or residents in the county. Now remember, under Title I, Section 8 of the United States Code, all United States persons are infants right away. Okay, you're an infant. So boom, right? Incompetent right away, right? But listen to this. So of the estate of all minors having estate within his county, of the person of all such minors who are inhabitants or residents. Notice how they make the difference, inhabitants or residents, right? Because they're different. A resident is a foreigner. That would be you as a United States person are now a resident of Michigan, but technically a citizen of the District of Columbia, right? In his county, and to have no father or mother living competent and suitable to have the custody and care of the education of the minor. Of any person who by excessive drinking or by gaming, idleness, or debauchery of any kind shall so spend, waste, or lessen his estate as to expose himself or his family to danger or want or suffering, or the county to charge or expense for the support of himself or family. So that's what I mean. As soon as you go get a benefit, right, you sign up for food stamp. Well, this is how it all started. That's what they did. The Great Depression, right? Stock market crash, Great Depression. And that's how they got everybody to contract with the United States who hadn't already contracted with the United States by offering them welfare because they needed it, because they were starving to death. And once the state starts taking care of your family, just like it says right here, you come under their guardianship. You are now their ward, right? Beneficium abstinende. He who accepts the benefit abstains from being the heir. Okay, you cannot be a beneficiary and an heir. You're one or the other. Anyway, let's see here. Debauchery, danger. Yep. Of all persons who are insane, imbecile, idiotic, or who, by reason of old age or disease, are mentally incompetent to have the care, custody, and management of their estate. Of the estate, but not of the person, as against the rights of the husband of any married woman who shall be insane or otherwise mentally incompetent. And it makes you wonder why they were locked. It kind of gives you insight into why they were locking so many people up in lunatic asylums during the late 18 and early 1900s. They're taking their fucking estates. That's what they're doing. Right? Yeah. Okay. Kundalini King actually said it right here. Right here. He says, I think of all the old asylums in every city. Absolutely. Right? So, yeah, insane are the ones who made up all this bullshit. You're right, Dorian. Absolutely. Yes, I can explain the difference between an heir and a beneficiary. So I'll give you an example. Say you've got a wealthy estate in a business, right? And your son, your heir, is an idiot. What would be your heir is an idiot. And you know that if he becomes the heir and takes over the estate, that he's going to squander it because he's an idiot. He's a spendthrift, or he's any of those other things that you just... So what you do is you appoint an executor to the estate in your will, right? That's not your son, but you name your son a beneficiary and not the heir. And now he receives a portion of the estate as a beneficiary, but he has no controlling interest in the estate. And he has to use what he's given in the way that he's told to by the executor. Does that make sense? So if you're a beneficiary, you cannot be the heir. All right. You're just given a portion of your, and this is an ancient maxim of law. It's beneficium abstinende. He who accepts the benefit abstains from being the heir. Okay, so that's where all these people, all these law gurus are talking about, oh, you can go, you're the beneficiary. Go into court and tell them you're the beneficiary. They'll fucking love if you tell them that you're the beneficiary, because they'll be like, yes, you are. And here's a compelled benefit. Go to jail. Right? Because it's all for the maintenance and upkeep of buildings. And we're going to look in, because that's the housing. Now, remember where I said everybody has a house? That's what the housing acts are. They're not houses like physical structures. That's what they want you to think, right? No, when they're talking about maintenance and upkeep of a house or housing, right, development, they're talking about the family. That's how tricky these fucking black magicians are. They're pieces of pirate shit, right? So anyway, so we've got that, and then there's some other things I was going to show you guys about this, right? So we pop over here, special administrators, boom. So this is still in the probate code. What the fuck? Where did that go? Damn it. It's really annoying. There. Okay. When by reason of delay in granting letters testamentary or of administration, or when any from other. So what happens nowadays, right, is you're abandoned by documentation. Okay. You're pledged to the state of Michigan. That's what your birth certificate is. Remember, there's only one seal on there that your mother signs, right? And of course, she's labeled as her maiden name. So you're also a bastard, because your parents don't have the same last name on the birth certificate, if your father's even on it, because they don't like to do that either. They make them do an affidavit of parentage, which is fucking asinine. But anyways, so you're already a bastard, even if your parents are married, and then you're abandoned by documentation and pledged to the state. And then the state pledges you to the United States, and the United States mortgages you. Okay. Well, actually, I'm not sure if it's not the state that mortgages you to the United States in exchange for federal funds. I do think that's, after reading this, especially, I'm pretty sure that's how it goes. And then of course, the federal government, the corporate United States, in turn mortgages your estate to the DTCC, the Depository Trust and Clearing Corporation, in order to be used as collateral to issue series of Federal Reserve notes. Also as the first mortgage that backs every security generated with your social security number, right? Whether it be a bond or a utility bill, because there's a big scam too with utilities, right? So that's considered a public benefit. That's why the utility companies and the energy companies are so important for these oligarchs to have control of. Is you're actually considered a form of energy. That's why you're a human resource. That's why these corporations label you as a human resource, because you are the resource, the battery that powers their fucking lifeless machine called a corporation, right? But the power companies, they're subsidized by the government from your trust, because they're providing you the benefit of electricity. And then, so they receive money from your trust already, right? That's why you have to use your social security number to sign up for electricity and all that shit, right? So they're already getting paid out of that. And then they turn around and double charge you, right? For something that's you're already paying, that's already paid for. And on top of that, they shouldn't even be charging anybody, because they use natural resources to generate the electricity that belongs to the people, and not to the utility company. The utility company can't claim the Mississippi River or the fucking Hoover Dam or any of that. So they can't do that. It's all public stuff. So that's a big scam, but I digress, right? Right here, special administrator. This is what all judges are, okay? They're all just special administrators. When by reason of delay in granting letters testamentary or of administration, and when from any other cause the judge of probate deems it expedient so to do, he may, after such notice as he may direct, without notice in his discretion, appoint a special administrator to act in collecting and taking charge of the estate of the deceased, and protecting and conserving the same until an executor or administrator shall be appointed, right? Such special administrator appointed according to the provisions of the preceding section shall collect all goods, chattels, and debts of the deceased, and preserve the same for the executor or administrator, who may afterwards be appointed, and for that purpose, upon order of the probate court, may commence and maintain actions as an administrator. These are what the courts do, right? They're levying charges, taking control of your estate in order to pay the debts, right, as special administrator, then creating a constructive trust. That's what they're actually administering. So they create the constructive trust first, and then they're administering it essentially to pay the debts that they claim that you owe. And what's interesting about that is that I'm pretty sure I pulled it up. They're supposed to deposit this shit in the treasury. So I'll get to that. So here's the fiduciary. Now, this is where it gets a little confusing for people, but fiduciary is a trustee, but it's a trustee with the ability to make financial decisions regarding the estate. So a fiduciary is not necessarily an administrator or an executor, which an administrator is appointed by operation of law because there's no will. An executor is actually appointed by will. That's why you say you're the executor, not the administrator. Say I'm the sole heir and executor of the res defendant estate. You fuck up the whole court if you say, I come before this court having been found to be living, and I am the sole heir and executor of the res defendant estate, meaning the trust, that the estate that you're trying to create a constructive trust out of through special administration. I'm the heir, and you cannot administer this estate. And why am I even in here? Because my property is not under, my will has not been probated. My property is not under administration. You can't tell me how to use my property because I own it. It's mine. Okay. And you have no business telling me what to do with it. And that'll fuck their court all the way up right away. So, but I found this interesting. So non-residents, right? So it's hereby declared to be public policy of this state to require that all persons acting in a representative capacity under appointment of a probate court as fiduciary shall at all times be amenable to process issued out of the courts of the state. And to that end, no person shall hereafter be deemed suitable or competent to act as a fiduciary who is not a resident of the state and a citizen of the United States. So that's how they switched everything over to make sure. Oh, and this is where it gets interesting. Provided that nothing herein shall be construed to limit the power of the court to appoint any bank or trust company authorized to do business in this state. And that's who your guardian actually is a trust company. And so the banks can act in a fiduciary capacity in your guardianship trust company. That's why Michigan has Michigan Trust. That's what that is. It's the guardian. Okay. They place, and each state has one, and it gets even deeper. That's why. So each county used to have a common council. Now guess what it's called? The Board of Trustees. Okay. That's who runs your counties, is the Board of Trustees. Because that's the trust that has guardianship over that specific area of chattel, essentially. So, let's see here. What else did I pull up here for you guys? There's more in this probate. Yeah, so depositing the funds of the county treasurer. So when any fiduciary shall have made approved final settlement with the probate court, it shall be the duty of the court to order said fiduciary in exchange for suitable receipts, right? To deposit with the county treasurer such money or personal property as he may have belonging. So settlement, exchange for suitable receipts. Where is it at? Hold on. There was something. There's a word in here called personalty, which is a very interesting word. And I'm trying to remember where I read it. In the event on the filing. So hold on. It shall be the duty of the treasurer in the area of legal appointment. Where the hell was that? Shall be the suitable to deposit such personal property. Hold on. Maybe it wasn't this section. Well, anyways, it's basically selling you in the court, and they're supposed to deposit all the profits made from it. But now I can't remember where I read that. There's a lot of stuff in here. honestly didn't even plan on going through this stuff, but I was just inspired to this morning, especially after I received a few comments with questions. But yeah, so they're supposed to deposit when any fiduciary shall have made approved final settlement with the probate court, it shall be the duty of the court to order the fiduciary in exchange for suitable receipts to deposit with the county treasurer such monies or personal property as he may have belonging to any heir, legatee, claimant whose whereabouts after diligent inquiry he cannot ascertain. That's the whole Set to KV Act, presuming you dead, which we'll actually get in that. It outlines this here. And if you're just tuning in, I want to point out too that this is almost impossible to find. If you try to look it up on Michigan's website, legislature.michigan.gov, it just says repealed, 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 because they piecemealed it out in different parts of the Michigan compiled laws. They didn't want it all, but when they originally passed it, they passed it all here so they could start selling the property of your estate, generating securities and exchanging them essentially. So where was I? Some duties, no. So letters of the, okay, here I was. So anyways, or to any person when the right of such person shall have been made subject to appeal from the probate court in the event that personal property other than money, blah, blah, blah. Yeah. So I had looked up the word personalty, specialty. So I'm thinking it's got to be here. No, but this is, okay, so this is the mortgaging of the estate too. The several judges of probate may by order license and empower any fiduciary of estates within their jurisdiction for the purpose of paying the debts of any deceased person. Now you got to remember, all United States citizens are paupers, okay, because you're infant paupers and you're dead to the law because you're bankrupt. You have no money. Okay, everything that we use for currency is based on your future sweat equity or the sweat equity of your descendants. And since you have no access to money, there is no actual buying or selling going on. It's only because of the Securities and Exchange Act of 1934 that you can even say the exchange of Federal Reserve notes for something is a sale, but it's not. Okay, it actually says that any exchange of securities can be considered a sale, right? The trade of securities can be called selling and buying. And that's only because of the Securities and Exchange Act. But you have to remember that the entire thing that backs this, so you're automatically an infant, and everything that they're doing is for your benefit because you're a pauper. And it's a privilege to be able to use these Federal Reserve notes in commerce. It's a benefit to be able to engage in commerce using debt notes, essentially. But if we just look at oops, I shouldn't open that. Hold on, I'll show you. If I don't already have it open. No, I don't. Okay, so 1933, I always like to show this in case you're new to the channel. GPO, I got to remember which 1933 it is, though. I think it's this one. No. Negative. This one? Oops. No, sorry. I've got this whole bankruptcy era is it's all good stuff. That's why I have so many documents from 1933. There we go. So it says that under the new law, this is 1933, under the new law, the money issued to the banks in return for government obligations, bills of exchange, draft notes, trade acceptances, and bankers' acceptances, the money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and all other property of all the people in the nation. That's called mortgaging your fucking estate. And the only way that they could do this is by first sheeting it under presumption. If you're a drunkard, a lunatic, a spendthrift, a pauper, an infant, you accept government benefits, whatever the case may be, they can take guardianship of your estate. They can bring you under wardship. And then they can turn around and do whatever is necessary with your property to maintain your estate. So please excuse me for a second. Coffee's run through me. I'll be back in 2 seconds, but you guys can read that for yourselves if you can see it, and just give me literally just a couple minutes. I'll be right back. Yep, I apologize about that. I been up all night because I work third shift, and so I've been drinking coffee to make sure I was alert enough to be able to give you guys this presentation. But yeah, this is called mortgaging your estate, right? And so what this is saying over here on this page is, yes, I was definitely dancing in my seat. I was trying to get through and find the mortgage in the congressional record before I pissed myself. Yes, that's very accurate. So it says that several judges of probate may, by order, license and empower any fiduciary of estates within their jurisdiction for the purpose of paying the debts of any deceased person or ward against the estate of any deceased person or ward, or paying the legacies provided in the last will of any deceased person, or supporting any ward, right? Or making necessary repairs to the buildings belonging to such estate or ward. And that's part of this, the Housing Act. It's the way that, in the same way that they treat you as farmland under the Federal Farm Loan Act, they treat you as a housing development as well. And so when they're talking about appropriating funds, which is all coming from your trust, well, it's a public charitable trust. So all these birth certificates are put up as collateral, right, as a mortgage, basically placing everybody under an indenture. Promising your sweat equity and revenue from the property through motor vehicle code and income tax and property tax and all this stuff, right? As repayment for the debt, but it's an ongoing thing. But what happens is the public charitable trust is put up by we'll just say a religious institution, okay? And that public charitable trust is what they borrow from. Now, just to remind you, the Federal Reserve, or the Rothschilds, more specifically, are guardians of the papal treasure. So who do you think puts up the public charitable trust? And the whole name of the game is for your benefit, being able to borrow from that or take from that trust and stuff into their own pockets the Federal Reserve debt notes that are generated from the mortgage of your estate, in the name of administering your estate and for your benefit and welfare. That's how they do everything, right? So that's why all under Title 42, right here, you'll look at all this is essentially this whole, here, hold on. This is Title 1, Section 8 of the U.S. Code. In determining the meaning of any act of Congress, right? Any ruling, regulation, blah, blah, blah. The words person, human being, child, and individual shall include, at the exclusion of everything else. When in statutory construction, when something says shall include, it means only this. Every infant member of the species, here, we'll highlight the whole thing. God damn it. All right. Every infant member of the species Homo sapiens who is born alive, right? Certificate of live birth, at any stage of development. So infant doesn't mean baby. Infant means somebody who is mentally incompetent is what they're meaning. The species Homo sapiens who is born alive at any stage of development. Why? Because infants cannot hold title. Okay, so then boom, automatically puts you under this. You're under probate, under guardianship, right? And it says, let's see here, repairs to the building, so they can take and sell you convey your property to fix stuff on the estate, right? The buildings, or here's where what's important, or for the purpose of completing the erection of buildings begun by such deceased person or ward, or by some person in his behalf or for his benefit. To borrow money by mortgaging or otherwise pledging, which this is what Colonel Mendel House said, we'll use the ancient system of pledging and we'll perfect the security interest over them, which is what they've done, because security is evidence of debt, right? So it all goes back to the birth certificate. It all goes back to probate. So anyways, otherwise pledging the estate of such deceased person or ward or any part thereof, and if the interest of the ward is that of tenant by the entirety or that of a joint tenant, the court may license the guardian under the provisions of this section to join in a mortgage with the other tenant, provided that the authority herein given to the mortgage or pledge estate for the payment of debts and legacies shall extend to such estate only as might be sold for such purpose, unless a mortgage or other lien exists against the homestead of such deceased person, or blah, blah, blah. Right? So the whole name of the game, right, was taking your estate, mortgaging it, and then placing you and your property under administration so they can play God and generate as much currency as they want. Right? So here's the thing, though, Dorian, they do control you unless you claim your estate, because that's how they get away with doing everything that they're doing, because you're an infant. You're an infant. Over in England, guaranteed the same thing, because that's where it came from. It came from the Court of Wards and Liveries. Okay, it came from, because that's what ended up happening. So you had the Magna Carta, because the barons were tired of the priest class taking the inheritance of their sons, right, and robbing their estates. So they had the Magna Carta. It's like, look, this is how inheritance and the administration of estates are going to go, with other things like grand jury and the ability to strain the king of property and all that stuff, right? And then it evolved from there to, like, so you had the first set the KV Acts, which declared people, anybody who's declared missing or presumed dead, their properties basically reverts back to the person who granted it, or to the holder, the lord who granted it, or ultimately the crown. And so they started so there came about a court called the Court of Wards and Liveries, and this is where an heir who was not of age yet would go and sue his guardian for his inheritance in the Court of Wards and Liveries. Well, then after the Set the KV Act of 1666, they eliminated the Court of Wards and Liveries and erected the Court of Wards, just wards. And that's where you came to sue out, basically to prove at an action at law, through an action at law, that you were living, in order to reclaim your estate, except for most of the people whose estates had been escheated under that act, because there was like 70,000 people died during the London fires, and then a bunch more prior to that during the plague, because they got hit with the plague and then the London fires back to back. A whole bunch of people died, and the people who did not know how to or even that they had to reclaim their estate. Right? So they just immediately came under administration. And so that's where it all came. So you guys have been infants basically since then. And guess why he did that? The king did that. King Charles II did that in order that the Bank of England, he could use the chattel that he now has, his subjects' estates that he now has administrative power over, as collateral to start the Bank of England. It's the same wash, rinse, repeat thing. Nero did it way back when he established the 12 tables. He burnt Rome to the ground with the consent of Senate, and then created the 12 tables and basically said, hey, if you haven't claimed to be alive, then you're going to be presumed dead. It's pretty much what he said, right? Same thing. And that's what we have here. So we have, I'm pretty sure I pulled it up. It basically talks about presuming that you're dead. So let's see, if we go up to the deceased estates, and it's the same 7 years. Sale of estate, of ward, grounds for license. It's what everything's taking place under probate, guys. The whole kit and caboodle. Everything is, what was that? Contingent claims. Here, you know what? I'll use this as a table of contents. It's chapter 2. Okay, chapter 2 that they won't let you see here on the legislature website, but fortunately, I've been gifted with excellent research ability, and I find anything I intend to. So let's go. That is chapter 6. Jeez. So there's so much, and I'll link this. I'll link this if you guys want to check it out. There's so many gems in this that just shows you how they're doing everything. Once you understand it's the administration of your estate. I'm going to put this in the chat. You guys can just read this at your leisure. Testamentary, appointment of guardian, shit. This is see, and they put, so it went from just a couple paragraphs back in 1827 to now they've codified the whole, and everything falls under this probate code now. Every single thing. That's why. So the term administration, actually, while I look for this, I'm going to do this for you guys. I'm going to show you something. Administration. Right? So when we look in the legal dictionary for administration, right, and we go to Bouvier's, right, the very first thing it says is administration, trusts. So the word administration is only ever talking about trusts. Okay, that's what the word administration is. Now, let me show you how they replaced our government here in Michigan in 1969. And longtime subscribers already know this because I've shown this many times. Well, yeah, you know what? We'll pull up the District Court Judges Association because that's relevant, because they're all special. All district court judges are actually just special administrators, all of them. That's all they're doing is it's an administrative hearing regarding an infant estate where the heir is presumed to be dead or missing because he never claimed his estate within the first 7 years of his life. And the United States person that is the trustee taking care of the estate is presumed to be an infant and also a pauper. Okay, then that's what they're doing. So yeah, we'll click this. And before I even show you what I'm going to show you on that, we're going to go here to, oh wait, you know what? We can go here. Close that. We'll go here and we're going to do the Administrative Procedures Act of 1969. There it is. Now, remember what I just showed you about the term administer. The term administration only is ever dealing with trusts, whether it be corporate or just a regular trust, right? So that's why you have a president that's the chief executive officer, because the federal government is a trust created by the states. Your state government is a trust created by the people. Corporations are just a form of a trust. So all administration is only dealing with trusts. Okay, so now we're going to go back to this Michigan Administrative Procedures Act. Okay, general provisions. So this is 1969, Act 306 of 1969, right? And we're going to go to rule. This is very interesting. L to R. Whoa, okay, where's R? Oh, it's going to make me go to next. Rule defined. Okay, so it means any agent, regulation, standards, policy, ruling, or instruction of general applicability that implements or applies law enforced or administered by the agency, right? So I'm going to just skip it. So we're going to go down here. It says it does not include the following. This is a double negative, so you guys really have to pay attention. Does not include the following. Okay, and then G, an intergovernmental, interagency, or intra-agency memorandum, directive, or communication that does not affect the rights or procedures and practices available to the public. What? So rule does not include, and we'll just leave out all the big words, right? And we'll just say rule does not include anything that does not affect the rights or procedures and practices available to the people. So does not affect. What does that mean? It means it affects you. Okay? It means it affects you. And they passed this because this is after they did the Uniform Commercial Code, after they had established that they've got the Trust Indenture Act, the Uniform Commercial Code, everything's been established. They've mortgaged the estates, and now the majority of everyone is just a bunch of infants under administration. Now they switched over from our real government to an administrative departments. Now the entire thing that you call government is just one big administrative corporation. That's it. It's not a government anymore. There are no laws. There's just rules that are either presented as compiled laws, statutes, or codes. and it's all just the administration of infant estates. Now, remember, this is Act 306 of 1969. Now, an association is a trade organization, okay, where they get to exchange securities, essentially. And look, Michigan District Judges Association. When was this established? Hold on. Let me zoom in for you. When was that established? 1969. Same time as the Administrative Procedures Act. Because all district court judges, these lower courts, well, all courts really, but especially the lower courts, are just special administrators. That's it. They are only special administrators. They're only, let's see here. No. I know I had it pulled up. Guardians and wards. Yeah, this is, but they're special administrators. I did have it pulled up somewhere. I don't know where the hell it went, but yeah, it said special administrator, and that's what the judge is. So we go back here, guardians and wards. So again, in case you're just now joining us, says that the judge of probate in each county may in all proper cases appoint guardians of inhabitants or residents, because remember, this is 39, in his county, and also such. This is where they made it to where only fiduciaries could only be foreigners to the state of Michigan, but citizens of the United States, of the District of Columbia. And in case you're new to that understanding, I actually have something for you. It's called elementary law, which I did leave open as soon as I can. It's one of these. Yeah. Boom. So members of the state, a member of a state. This is from 1933. This is very great. It's very good treatise, and it's very rare to find a good treatise after 1900 in general, but this one's good. So a member of a state may either be a citizen occupying the status entitled citizenship, or he may be a resident alien occupying the status designated by the title residence. A citizen is a permanent member of the state, owes his allegiance at all times, and is entitled to its permanent protection whether he is at home or abroad. Okay. The status of his citizenship, is distinguished by its permanent and personal nature, and may be determined by the place of his birth, jus soli, which means the law of the soil, or by the nationality of his parents, jus sanguinis, which means the law of the blood. See how old this stuff is? Inheritance, right? By his election or by some form of naturalization. Now we get to a resident. A resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen. He owes the state, blah, 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 right? He owes the state of his sojourn allegiance and is entitled to its protection during his stay. The status of his membership residence is distinguished by its temporary and local nature. That's why when you are a 14th Amendment United States citizen, an infant, a debt slave, you are a foreigner in your own country because your country is your state. And we go over this almost every stream because I really want to drive this home. Your country is your state. The United States is a corporation. Okay? And it's actually the District of Columbia, created by the Organic Act of 1871, doing business as the United States, because the original United States, that was the trust created by the several Confederate states, and all states are Confederate because the Articles of Confederation created them, and I've proven that over and over again. That original trust was dissolved when Congress went sin die. Okay. So, yeah. Back to the probate code, because I want to show you guys one more thing. We're going to go to chapter 2, which is the decedent estates, which is how you're listed in your IRS master file as a decedent. Okay. Where's that? Descent, distribution, and partition of estates, descents of real property. We go up a little bit further. Yeah, it's a long section. This is how they alienate you from your estate. intestate estates, blah, blah, blah. We're going to look where they presume. This is where they lay out essentially the Set to KV Act of 1666. So in the way that they use the exact terminology out of the Magna Carta, they also use the same terminology and time frames from the Set to KV Act of 1666. So notice how it says decedent estates, wills, and the probate thereof. So when you think of the term will, everybody thinks about the document you write before you die to determine how your estate is the disposition of your estate after your death. But that's just your last will. Okay. Your will is ongoing, right? And so when your will has been probated, and your property's under administration, you're literally on probation and you do not have free will. You are told what to do with your property, right? So everybody's tricked into thinking that will just means your last will. No, that's just your last will. But everything you do is your will. When you acquire property, it's the ultimate realization of your will. Yes, Dorian, that will be done. Exactly. Whoops, here. So let's see here. And Jerry, son of Mick, says, did you have a look at Windows on the World last night, Dorian? Oh, Apostles. Yeah, I like that guy also. The Windows on the World fella. He's pretty good. But anyway, so real estate, right to dispose of by will. Every person of full age and sound mind being seized in his own right of any lands or right thereto, or entitled to any interest therein, descendable to his heirs, may devise and dispose of the same by his last will and testament writing, and all such estate not disposed of by the will shall descend as the estate of an intestate, being chargeable in both cases with the payment of all of his debts. So boom, right there. And notice that that's all common law. That's right out of the Magna Carta. That's why the Magna Carta is the first document of the very first Michigan compiled laws. Okay, because this is what they're using. I cannot stress this enough. The Magna Carta is a double-edged sword. If you do not know it, it's used against you. If you do know it, you can damn sure use it against them. And that is what they do not want that at all. Right? At all. So, let's see here. Will requirements, blah, blah, blah. And we want to go down to, this is all about decedent estates. So, we want to go down to the amount of time that they give you. Or is it even one up? Let me see. It might be even one. Probate courts? No, it's got to be, it's got to be that one. So, sorry, this is a long, oh, there's the special administrators. Yeah, so boom, that's what all district court judges are. Letters of authority, non-residents. Delivery of assets. Where the hell was I just at? I got too many things open. So we were just on section 2. Yeah, okay, so this has got to be it. So I'm looking for the presumption of death. Debts, Essentially, it's 7 years. That's what it says in here. If I don't end up finding it, because this is taken forever, but settlement of contests. But it basically says that if you don't claim your estate, or if you're presumed to be missing, and anybody who knows you hasn't heard of you, and they put out a notice, you have 7 years, right? 7 years. And then they escheat your estate. And that basically means from when you're born till you're 7 years old, because as soon as your parents pledge you to whatever state your birth certificate is, because that certificate is, they register you with the state. So they're abandoning you by documentation and giving you to the state. And then the state then pledges you as security for the issuance of Federal Reserve notes. Ultimately, they pledge you and they get paid by the United States, right, for each birth, and then the United States mortgages it, and that's how the Federal Reserve issues currency, as we seen right here, where it says that the money's worth 100 cents on the dollar because it's backed by the credit of the nation. It represents a mortgage on all the homes and other property of all the people in the nation. Well, the only way they can do that is if they mortgage your property rights, because how can they mortgage something before you have it, right? The only way they can do that is if they've mortgaged your estate, and your estate is essentially everything you own at law. It's your property rights, and they do that through probate. But anyways, I do not remember where it's at in here, but yeah, there's a lot of stuff. It's 7 years though. I do have that for sure. It's definitely 7 years, and it's in here. And like I said, I gave you guys a copy of the link in the chat. And yeah, here it is. Okay, I found it right when I was about to give up. So estates of disappeared persons. Of course, it's gonna there. The property, both real and personal, in the state of Michigan, of any person who has left for any reason whatsoever his last place of abode, as known by those persons most likely to know the same, shall be subject to the provisions of this act, provided that the absence has the following characteristics. The absence shall be for the continuous period of 7 years. The whereabouts of the person shall have, and it's funny because all of the, so after this, and you know what, next show that I do will be on the Uniform Law Commission, because there's actually this unelected body of lawyers that writes the template commercial laws for the states to adopt, and they're called the Uniform Law Commission. It's basically, like I said, an unelected group of pirates that somehow control the people who are supposed to be enacting legislation through their, because you know, your senators and your congressmen and all these people, they don't actually write the laws. Okay, they have an assistant that gets their marching orders from the Uniform Law Commission. And the way the Uniform Law Commission operates, actually, we can look at it real quick. We'll go to ULC. Yeah, sure. Why not? Uniform Law Commission website. Home, ULC. Boom. You go to legislation, legislative activity. Why are they legislating anything? They're not part of the government. So, fuck it. We'll go to legislative report by state. Okay, let's see. Only one. Antitrust Pre-Merger Notification Act, Collaborative Law Act, Antitrust, Civil Remedies for Unauthorized Disclosure of Intimate Images Act. See, but the funny thing about all of these laws, this is not a governmental body. This is just a bar association organization. And what they do is they sit back and they draft all these templates, and then they suggest them to the states for adoption, right? So let's go back to by act. Sure, legislative report by act. Well, look, why can't, where the fuck, there was a point in time when I was able to look at the documents on here. If you wish to search a specific, so it's not going to give me access to the text. So I actually have something I got off of this website, right? So it's called the Uniform Disposition of Unclaimed Property, and it aligns right with the probate code, by the way. So uniform, actually, I wonder if I deleted it. Yeah, there it is. No, I didn't. So Uniform Unclaimed Property Act. This is a ULC. See, National Conference of Commissioners on Uniform State Laws, approved and recommended for enactment in all states. Recommended, right? Recommended by the very bar pirates. And make no mistake, the bar association is and always has been your greatest enemy. There would be no central bank if there wasn't for the bar association. They're the ones who have been extra excited about removing the knowledge of common law from the public zeitgeist, let's say, right? In fact, I can even show you how excited they were over here in the Michigan Judicature Act of 1914. These fucking pirates right away, right? Because I told you, Michigan was super excited to enslave its people. Like from its very, very beginning, this state has been all about English law, enslavement through equity, 100%. So, where is it at? So the only reason, so chancery is equity. Okay. So it says the parties to all actions shall be called plaintiffs and defendants instead of having a multiplicity of names by which to designate the party suing and the party sued. That's because in each different jurisdiction, common law, equity, or which is also chancery, probate, and of course military, they all have different names for the plaintiff and the defendant, which it's not plaintiff and defendant. But anyways, it's claimant, right, is one. Petitioner is another one. So anyways, this is what, okay, right here, number one, the matter of the abolition of common law forms of action has been the subject of a great deal of debate throughout the country for many years. We recommend the abolition of all such forms of actions, except the actions of assumpsit, trespass on the case, replevin, ejectment, and senatori. Now, remember what I've taught you guys. The only way you can be removed from common law is by contract or presumption. There's only 5 jurisdictions of American jurisprudence, okay? And really just 5 jurisdictions of jurisprudence in general in any Western Anglo society. And that would be common law is the very base ground jurisdiction, okay? And then one of your common law natural rights is to be able to contract. And the enforcement of contracts is equity. That's the next one. Those are the only 2 jurisdictions of law that the Constitution actually specifically names, the federal Constitution. Okay, those only just law and equity. It's Article 3, Section 2 says that the judicial branch of government shall have jurisdiction in all cases of law and equity. And the reason that it distinguishes between the two is because equity is not law. It's the enforcement of private law of agreement or contract. And you're only under that private law if you agree to be under it via contract. So that's how you come under private laws. But law is common law, and it's based on natural law, and it's not written by man. It's only recognized. Okay, so that's why the Constitution makes a distinction between law and equity. All right. And so you come out of common law into equity through the enforcement of contracts if you contract. And you can deal with contracts at common law, but they like to deal with contracts in equity because then you can deal with pre-crime, right? Equity, common law, because it's based on natural law, it's not written by man, it's only recognized. It only deals with what is and what has happened. It never deals with the could be, would be, should be, might be. None of that. But equity does through a form called, or through an equity action called injunction. You can prevent somebody from doing something in the future, right? And see, that's why the lawyers are so excited into moving into the realm of equity, because they can then play God and use their imagination through contract to get people to agree to all sorts of shit. So as we'll read here, this lawyer is super excited about abolishing common law. We recommend the abolition of all such forms of action, right? And he says, it has seemed to us practicable to go so very far in matters of substance in abolishing the distinction between legal and equitable proceedings. Right now, it's all equity. We propose that actions have been brought on the wrong side of the court and may be transferred to the right side and begin with instead of being dismissed, thus rendering and beginning a new action unnecessary. See, it was hard for them to it was just, it inconvenienced the attorney to have to go back and forth between common law forms of action and equity, right? So like I said, common law is the foundational, that's the sovereign law. That's you not bound by the institutions of your fellow man absent consent. But once you consent, then it's equity, okay? And then there's other forms of jurisdiction are admiralty, which is international trade, basically shipping, merchant marine, whatever, then you're under admiralty. That's international law. It's lex mercatoria, essentially. And then, which is the law merchant. So you've got common law, equity, which is the enforcement of contracts, admiralty, let's just call it international trade. And then you've got military, which requires you to contract to be in the military. Then you're under military law, right? Court martial. Or probate. Now, probate is the only one that can pull you out of common law under presumption, as we've read, presumption of being a spendthrift, a drunkard, a distracted person, an imbecile, an idiot, or an infant being not of age, which is what all United States persons are, infants. And that's how probate has taken you out of common law and put you into equity through the administration of your estate. So it's all special administrative hearings, because the way they set it up is the jurisdiction of probate and the jurisdiction of equity are the same. So matters of probate and special administrative hearings are held as courts of equity, but they're actually special administrative hearings. So I hope you guys are following me, because I know it can be a little confusing at first, but you see how excited they are to get rid of this, right? Common law. The proposal is in line with the new Federal Equity Rule 22, the New Jersey Practice Act, and the English Judicature Act. Why would we be adopting any fucking English anything? But again, this is 1914, right after the Federal Reserve was established. And I told you, Michigan the entire time has been super excited to enslave the people of Michigan, because it's a bunch of fucking scumbag attorneys that founded the state. So, and they're a bunch of greedy, fat, inbred piece of shit oligarchs. That's what they are. I despise them. So, anyways, back to what I was discussing, which was, shit, I bounced around quite a little bit. Sorry about that, guys. Nope, I don't remember now. I know I was talking about something initially, and then I bounced over to that Michigan Judicature Act. Citizenship, where was I, guys? International law and oxymoron. Who's the sovereign Poseidon? Well, it's interesting you say that. No, it's essentially the common law of trade between sovereign nations. That's what international law is. So you could say it's the common law of trade would be international. That's what Lex Mercatoria would be, the common law of merchants, essentially. And that's, so you're talking about going all the way back to the ancient Phoenicians, Babylonians, you know what I mean? Like and how that law is developed and stayed pretty much the same. I mean, just keep advancing with technology, obviously, all the way up to today, where it's still pretty much, the same. Like used to bonds, bottomry bonds, bills of lading, shipping manifests, all the stuff it's been the same for a long time. So you'd call it like the common law of trade between sovereign nations, I guess is how you could kind of look at that. That makes sense. But yeah, that is funny. Who's the sovereign Poseidon? Yeah, right. No, it's just pretty much like, and what common law essentially is the ancient customs, practices, and usages of a particular people. So when you say common law that's why I make a distinction and say Anglo common law when I talk about Western, you know what I mean? But a common law is, it's just that. It's the ancient customs, practices, and usages of a particular people. Anglo common law is, like I said, biblical. And then, I mean, essentially, even Roman, like ancient Roman laws, is kind of similar. And so it shows kind of like one origin of mankind understanding that only the creator makes law, or, the gods or whatever, however they looked at it, makes law. The divine authority makes law, and man can only recognize it. The only thing man can actually, quote unquote, make law about is the regulation of commerce, which is why they used Article 1, Section 8 here in the United States to drag the entirety of everybody under presumption of infancy and being United States personnel, you know what I mean, under the Commerce Clause. So now they can arbitrarily legislate regarding your property under commercial contract. And that's pretty much what's going on. So anyways, I'm running on 2 hours now. So I hope this has been an informative podcast. Definitely necessary before you can even begin to start thinking about reclaiming your estate. You have to understand this is the way law really works. Okay. It's all about houses and estates. All right. And, yeah, I mean, that's why everything regarding common law specifically which is the law of sovereigns, is regarding inheritance and descent. And again, I'll run through it one last time. We got the Magna Carta, right? We got the Magna Carta somewhere. Hold on. I know, here. So right here, as soon as, boom, 2, if an earl, baron, or other person that hold land directly of the crown for military service shall die, and at his death his heir shall be of full age, right? Boom, right away, talking about heirs and how to deal with heirs who are not of age and who gets to administer the estate. So you've got this all the way back in 1215. So we'll fast forward to the 1800s, where you have the Organic Acts of the Territories, which is right, not there, here. This, so you're going ahead about 600 years, and boom, right in the second paragraph, that the estates, both of the resident and non-resident proprietors of said territory dying intestate, which means without a will, shall descend to and be distributed among their children and the descendants of a deceased child in equal parts, blah, blah. They even talk about there's no distinction between whole or half blood. It'll go to the nearest relative, blah, 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 right? So boom, automatically talking about estates. And that's everything. That's the whole basis of common law, is essentially your estate and your status in relationship to your estate, which is where the term status comes from. So you have to understand that you have a house, or you're supposed to establish a house, have a seal, and have claim over your estate, have absolute claim over your estate. Now that we have that understanding down, or you should, these are the first 3 steps that we do once we, if you guys are interested in actually learning how to do this stuff. So, yeah, and it's fundamental understanding. So I'm starting to get very, very tired and a little loopy. So I think I'm going to shut it down before I start sounding dumb. Okay, but I appreciate you guys joining me this morning and going through this little law lesson that we've had here. And just remember that they mortgaged your estates right here, proven, House Congressional Record, March 9th, 1933, page 83, second paragraph on the left-hand page. They've mortgaged your estate to back the security, the Federal Reserve notes. And that's what everything is the administration of your property that's been mortgaged. And you're presumed to be dead and missing as one of the people, and you're presumed to be an infant as a United States person. So that's what's going on. Let's go through a few questions, comments, and then I'm going to get out of here for the day. All right. So natural law is occulted, hidden mainly to maintain power. That's absolutely right, Penguin. That's what they were talking about in the Judicature Act I showed you, where they said, oh, we need to move away. We need to abolish all such forms of action, as if they could. Here, that's the funny thing when they say abolish. So they're not the ones who give permission. That even to be holding court, they're borrowing a portion of our sovereignty that we've vested them with. Okay, so they don't get to tell us whether or not we can file an action at law. That's our prerogative. That's our absolute right. We can file an action at law. We can hold our own court because we're sovereigns without subjects. We're peerage. We hold court. Okay, that's what you do when you file in common law, or at common law in a superior court of record. There is no judge. There's just a magistrate. The magistrate's a paper pusher who does what he's told, and the jury. It's either the person who filed the action against the other person is the sovereign tribunal authority, or it is a jury if the defendant requests a jury. But there is no judge, and the magistrate has no tribunal powers, cannot do anything. He can only hold somebody in contempt if you tell him to. So that's pretty much it. And that's how a common law court actually works. That's why the attorney wanted to get rid of it so bad, because he can't play God in his little black robe, his little faggy black robe that he wears with the fucking dick and balls he likes to smack on the fucking on that little, on his desk. See, I'm starting to say, can't even think of it. On his desk, it is a dick and balls, so the gavel's a phallic symbol. So, and he, that's the whole thing. You can't do that in common law. He has to be, you have to be in chancery or equity for there to be a judge, and for him to be able to enforce his private conscience. And that's what's going on there. So they can't abolish it. When the attorney's sitting there talking about we must abolish all forms of action, you can still right now go file an at-law claim on anybody. And I recommend that's what I'm going to teach you how to do in the membership classes. Is I'm going to teach you how to file an at-law counterclaim. If some pirate gives you a ticket, then you turn around and you can file an at-law counterclaim and usurp the authority of the court, essentially. And of course, they're going to fight you on it, and you take them through the administrative process to a default judgment, right? Or it'll be a default if you can get a judge to approve, but you can still file the default on the record. And like in Colorado, that creates a lien on the person's property at law, because common law is still the foundation of this entire system, and it cannot go anywhere because everything else is built up on top of it through probate, which is part of common law. I hope that makes sense. That's how they were able to grandfather in the ability to administer your estate, was through the probate section created by the Magna Carta. It's not called probate in the Magna Carta, it's ecclesiastical court, but and it's not even called that, but that's what it is. They could only do that by the authority of the Magna Carta, which is common law. So, all right, let's see what else we have here. God's will versus the will of tyrants. Yes. Joseph says, we'll need to rewatch when I ain't rolling smokes. Too much info. Appreciate you. No problem, man. It says, well, what did anti-whiteism? He says, so international law, when applied to past World War II, UN human rights crap, which attempts to usurp natural sovereignty, is that separate? Well, those are treaties between nations. But here's the thing about that, though, is that the United States, again, that's entered into any treaty is not the original feudal trust created by the several states. It is now the District of Columbia Corporation doing business as the United States, and has fuck all to do with the people of the several states. So it doesn't matter what the hell they think they enter. That's them. Then they can go be a part of it. Just like the entirety of the debt right now that we supposedly owe, the 38, 40 trillion, whatever it is now, that's not that's Congress's debt. Okay. It's not our fault that they unlawfully, essentially hypothecated our estates and used it as collateral and pledged something that was not theirs. That once you claim your estate on the record, you take that right away from them. There's nothing they can do about it. That's you're going to leave Congress holding the bag. They can fucking pay that debt because that's not our debt, right? That's not our debt. So I don't know what to tell you. It says it right here on this fucking this congressional record that they mortgaged the estates of United States persons, right? But see, the 14th Amendment created, or at least recognized for the first time, the concept of a federal citizen. There's no federal citizen. And what that is actually an employee of the District of Columbia, because it came after, well, actually it was just prior to the Organic Act of 1871. But that was the point. So they could then get you to contract into being federal personnel, so on and so forth. It's their shit. It's not ours, right? Because we're not federal people. I'm not a citizen of the District of Columbia. I'm one of the people of Michigan. So that's my country. I don't know what to tell them. All right, let's look at a few other comments. Make stupid people famous said, greeting lost at sea, tax chattel, infant entitled slaves of the Vatican demons. I love it. That's awesome. Hope everyone seeks salvation. Only one way out. Yeah, that's true. Let's see. You're welcome, Dylan. Let's see. Anti-whiteism says, Brendan O'Connell. Program is going live when you're done. Recommend you give him a watch. Oh, Brendan O'Connell. Not sure who that is, but Peg said, thanks. See you next time. You know me, I've usually got to stand and talk for a few minutes. What if the parents don't get their children birth certificates from the county, state, and don't get social security cards? Well, that is an interesting question, isn't it? Because then they've made society as such that the child cannot exercise their natural rights. You can't exercise your natural rights with your child. I mean, idealistically, yeah, that's how it should, that you shouldn't do that, right? But then you have to be financially independent to actually be able to do that initially. You know what I mean? So I mean, yeah, why not? I mean, I don't really want to say anything about my situation, but I've pretty much working that out myself. And you know, because the whole thing is you claim your child as part of your estate. You should never send your child to public school anyway. But yeah, I mean, yeah, just don't. Yeah, just don't do it in the first place. Yeah, why would you mortgage them? See, what they try to do though is they try to come at you as if like, okay, well, you're already chattel, right? So it's the progeny of their property, essentially. So if you've already removed yourself from the system, then yeah, there's nothing they can do about it. And that's pretty much what that is. So perpetual war. All right, so does that mean a family bloodline can never recover or and have an heir once as a sole beneficiary? Can a beneficiary have a son suitable to be an heir and back in control? Well, yeah, if you're talking about the previous example I gave, then that would generally be the idea. So you would appoint an executor by will, and it'd have to be somebody you trust because there'd be a lot, there'd of course be the chance that he just would never choose an heir, but that would choose, somebody suitable from your bloodline that could run the company. It would have to be in your will, obviously. Otherwise it would just be in a trust, and the executor would obviously appoint another executor, et cetera, et cetera. So there have to be like some termination to the executorship and an appointment of an heir after your will. So yeah, you'd have to work that out. You'd have to be forward thinking in your will. It's definitely a lot deeper than the basic example I was giving, but essentially, yeah, you'd have to be forward thinking in your will of like, okay, so my son's not going to be the heir because he's an idiot. He'll be a beneficiary. He'll receive a portion of the estate, have no controlling interest, but I do want it to stay in my family. So I'm going to appoint this executor, and part of his responsibilities per my will be to appoint someone of my blood, whether it be your grandson when your son finally has a kid, or somebody that's, meets the criteria that you require to run your business. Yeah. So let's see. I do not consent. So Simbad, yeah, so far I've set up the YouTube side of it. I don't know if you have a YouTube account. It's Burn the Corporate Fiction at obviously on YouTube. I'm the only one with that name, I'm pretty sure, because I've never seen anybody else have it. I'm trying to figure out how to get it up on Rumble as well. Like if I can do a dual members only thing, I'm not sure how that's going to work yet. I'm just starting with YouTube and seeing how that goes. I'm playing with the platform. I might not even keep it on YouTube. Well, yeah, I probably will. Because YouTube's a great place for the law discussions, right? Not so much for the other stuff when we're talking about like, triangular shaped food gate and all that. That's for Rumble. But like YouTube, there's nothing they can do about me talking about the law. And this is where you maximize your reach of people. I don't know why people still stay on YouTube, but they seem to. So I know in other countries, they don't really have a choice because they're censored. So let's see here. Looking at individual sovereignty, Scottish clan, Roman, paterfamilia, house estate, etc. If the seal is the house patriarch, what do multiple sons use if under him or not? So yeah, that's kind of like, okay, so that's an instance where a son would perhaps start his own house, you know what I mean? Or branch off as part of the family, but, start his own house and estate. Generally it's the oldest son that's the heir, to the estate. But then, so think of it like, I guess it would, the best way to think of it would be to think of it like Game of Thrones, or like how a king passes on his kingdom, which is just a macrocosmic estate. So like the second born and the third born, they're princes, they get benefits of the estate, stuff like that, but they don't have the controlling interest of the estate, though usually they're given an important responsibility. Or look how the Rothschilds run their estate, actually. That's a perfect example of how to answer that question. So like the eldest son is the one who becomes the head. It's in their laws of their, yes, and their family has their own laws. the eldest son becomes the head, but generally the other brothers and family members are given important positions within the family estate, family trust. So, or you can go start your own shit, but the oldest son's generally going to be the heir. Then why do we send money to the IRS? Because they're extorting you. Well, it's this simple. It's actually the Tax Act, the Corporate Tax Act of 1909. Remember when I said a corporation is a form of a trust, right? So what they're doing is they're charging you, they're fining and feeing you for the use of an estate that they presume not to be yours, if that makes sense. So it's all the income tax stuff is under gift and estate tax, right? Like the W-4 and all that is a gift and estate tax in the tax code. And so they can't actually take your money if you're one of the people, but they can tax corporations and trusts. And so that's what they're doing, is taxing corporations and trusts. And so they treat you as a trust, as a trustee. It's the Social Security trust that you're a trustee of your Social Security trust, basically, your United States citizenship trust. Does that make sense? Because it's the corporate tax. That's the only thing that they've ever been able to tax the income, quote unquote, of as a corporation. So, yes, you could. But really what you do is you get your own. And they've stopped doing it, last I've heard. But essentially you get your master file, and then you get your EIN for your estate, basically, from the IRS. But I mean, really, in all reality, just stop participating in their system. That's the goal. Why even fuck with it? You know what I mean? What are you going to do? Why would you want to be in their system at all? You know what I mean? Okay, so is it possible for a family, community, town, county to create a document to record and authenticate the birth of an infant? Yeah. So actually births were recorded in the family Bible. That's how, under common law, that's how births are recorded, in the family Bible. That's it. That's accepted at law, at common law. So, live like Titus. Free streams, you'll post them today. If you're looking for that, I'm not Men of the West. I mean, I've never really thought about it. If it's, I'm not really sure how to respond to that. I didn't know there was a genre of music that's white positive music, I guess. But what'd you say it was? It's Men of the West. I'll check it out. Yeah, why not? So, all right, guys. Well, look, I've really got to go to bed. I've stayed up late and ran the stream a lot longer than I wanted to. Hopefully I answered your question satisfactorily. I'll bring up the corporate. Well, shit. Hopefully I remember. Corporate Tax Act of 1909. That's the only way they can actually charge you income tax, is if they're charging the estate. They're not charging you. It's actually unconstitutional. Like, for instance, California cannot charge an income tax, so they charge a franchise tax, which is the same thing. It's the United States elective franchise, basically through the Social Security number and the trust that's created. But anyways, thank you guys for, yes. Okay. Last question I'll take. Would claiming our estate abolish having? Yeah, absolutely. It abolishes. Yeah. That's the whole point. Because income tax and property tax and all that, again, is an administrative fee for the use of an estate that they presume, like you're profiting off of an estate that they presume is not yours and is under their administration. So they charge you a fee for the use of it in the form of property taxes or income taxes. That's the easiest way to explain it. But all right, guys, you have an excellent evening, and I will, their usernames. I got you. I will probably stream again on, what the hell is today? Monday? Working third shift messes your days up real bad. Okay, so Monday, probably Wednesday, I'll be doing another stream. So I will see you guys Wednesday. Let me know in the comments what you think. If you have any questions or comments, or whatever you guys, if there's anything I missed or did not explain properly, or you need more clarification on, just put it in the comments. I've been really good about answering those, and I'll see you guys Wednesday. Have a good day or evening or whatever time it is, wherever you're tuning in from. I'll talk to you guys later.